Thank you, everyone. We will reconvene and look forward to the presentation coming from the Department of Conservation. So, not too sure if it'd be nice to have an introduction as to who we've got here and how you're going to progress. So, in your hands.
Tēnā koutou, called Kerry Warnock tōku ingoa. Good afternoon, my name is Kerry Warnock and I am Counsel for the Director General of Conservation. With me today we have Liz Williams, who is our planning expert. We have Jusa Zammit-Ross, who is a terrestrial ecologist, and we have Bruce McKinley, who is also a terrestrial ecologist. I should start by saying the Director General, of course, has a statutory duty to advocate for biodiversity, and that's why we're here. She has a particular interest in protecting significant indigenous vegetation and protecting significant habitats of indigenous fauna. Now, the panel has my legal submissions from the 17th of February, and I trust that you've been able to consider those. But I think it's perhaps not overstating it to say things have moved on somewhat since I filed those submissions. And despite the panel's decision not to require additional evidence to be filed in respect of proposed ECO Rule 2 in particular, 6 statements were served on DOC and presumably other submitters at 4:45 on Thursday the 20th of February. It's probably a good example of being careful what you wish for, but I need to be quite candid with the panel. There's been one working day for the DOC team to consider that evidence before appearing before you. You know, due to existing commitments, the team individually and collectively has only been able to consider that evidence in a highly cursory fashion, and we have not been able to prepare considered written evidence or considered written legal submissions in response. So to some extent we're in the panel's hands as to how to proceed. We're all here and we're very keen to help you to the best of our abilities. I'm certainly able to give oral legal submissions in response to what we've received, and perhaps if the panel would find it helpful I can put those into writing afterwards and file them. Mr. McKinley, our senior technical advisor, who I was embarrassing before by saying I think he's got half a century of expertise in terms of ecological assessments, at least had some capacity to consider the additional evidence over the weekend. And he's very willing to answer your questions as best he can in relation to the Hokonui Hills ecological assessment, the methodology that was undertaken, the need for a significance assessment and lack thereof, whether the suggestion that the permitted clearance rules in SEVAs would lead to an overall net gain in indigenous biodiversity, whether that contention is valid. He's willing to help you as much as possible today. Liz Williams, our planner, is also prepared to comment orally on the additional evidence that's been filed, if that would assist. But if any stage we're not able to answer, I think it's important that we be candid and we say, look, we can't just answer off the cuff. It's not going to help you. We need to go away and be considered about it.
Yeah, if I can just respond to your question, and I guess by way of introduction, I can remember when Mr. McKinley joined the Wildlife Service, as it was in those days, and was part of the interaction that I had with various government departments in my role at the time. In terms of the evidence and your comments about the way that it came in last week, it addresses the matters that are in your evidence, and I saw it as helpful being a response to what was in your evidence, that at least you had a couple of days before the hearing rather than hearing on the day of the hearing. So from that point of view, I anticipated there would be an oral response, and if as part of our deliberations we decide we actually need more, then we can issue a minute asking for more, but fully understanding that you come prepared the best you can, and you'll give us the best advice that you can, and if there's any issues that do arise where we ask questions and you would like more time to think about it, then let us know.
That's very helpful. Thank you for that indication. Well, perhaps I'll start with some core points in respect of the legal submissions that are responding to the additional evidence we now have. I'm very conscious that we have a highly experienced panel, and some of this might be quite basic, but I do want to set it out clearly so that our position is well understood by everybody, not just the panel. So the first core point is that the Resource Management Act, the NPS-IB, the Southland Regional Policy Statement and Plan all treat the management of Indigenous biodiversity differently, depending on whether it is significant or not. Now that might seem a little bit simplistic, but as I've sat and listened to the evidence today, and as I've read the evidence over the last week, there has been conflation of that idea that you differentiate between significant Indigenous biodiversity and other biodiversity, and the management regimes are different. Accordingly, before the appropriate management regime can be determined, either through plan rules or through a resource consent, decision makers generally require an ecological assessment of the significance of the relevant Indigenous biodiversity. So best practice has now codified into a clear regulatory response towards assessing significance. There's a framework for how ecologists do it. We see that in NPS-IB Appendix 1, we see it in the Southland Regional Policy Statement, Appendix 3. So there's a framework for how you do it, and as Mr. Wells said, whilst there may be some differences in the detail, the core values are the same. Regulatory approaches to assessing significance requires a list of factors to be considered. These factors are not arbitrary or random, they're very carefully chosen, and they are individually and collectively important. Identifying why an area is significant is important, because in considering potential activities and effects in that area, decision makers must consider whether those activities and effects will destroy the reason that the area was assessed as significant in the first place. Now, what I have got, if the panel would find it helpful, and you may not, is an example. I can hand this out. We've now got plenty of copies of a significance assessment. It's not from anything to do with Gore or Stony Creek. It's from another case Doc was involved in. We didn't actually agree with it. We picked holes in it, but it gives you an example of what a significance assessment looks like. And if that would assist, I can file it with the panel and hand it out to you.
And I also see that Coral is now with us. So at some point, I guess after you've finished your submissions, we'd like to hear from her, as we discussed just
yes,
before. Okay.
I shan't be too long.
Okay.
So to give you an example,
yes, please hand them out.
I'll hand those out, just so that you can see the sort of information and assessment that one would expect. And I should say, actually, that was part of a much wider assessment. It identified ecological communities, it listed the plants in those ecological communities, and it also mapped threatened and at-risk species. But just putting that aside for one moment, to give you an example as to why identifying why an area is significant is important, I'll refer to NPS-IB Appendix 1D. So this is the list of criteria that you would consider in a significance assessment. And Appendix 1D is concerned with ecological context. And to summarise, it basically says the size, shape and configuration of an area may be important characteristics that help to maintain Indigenous biodiversity in an area, leading to that Indigenous biodiversity being classified as significant. So you need to know that area has been classified significant in that way to assess how activities and effects may undermine that classification. So an area that is important because of its ecological context, well, fragmenting that area by introducing tracks or fences may actually undermine the ecological context. Species listed on the New Zealand Threat Classification System as threatened and at risk will always contribute to an area's significance. And that is why in my submission, inadequate ecological assessments of significance, threatened and at-risk species, in terms of vegetation and significant habitats of threatened and at-risk fauna, will be plotted. Now, I just want to refer you, having spoken about the need for significance.
Can I just check your use of the word plotted as opposed to mapped?
Mapped and indicated on the map. So if you have specific...
so the actual GPS locations?
Yes. So having explained or touched upon the need for adequate significance assessments, I want to refer you to paragraph 217 of Glenn Davis supplementary evidence.
So just give us a moment to get that. .17, not 217.
Yes, 2.17, 2.17. It's supplementary that was filed on the 20th of February. Yeah. So in 216, Mr. Davis talks about significance. And then in 217, he says, notwithstanding the above, it was not the intention of the working group to consider the ecological significance of the communities on Stony Creek. Rather, it was to use ecological information to develop a suite of rules that will be cognizant of the biodiversity of Stony Creek, while providing some scope to allow the installation of new fences and tracks and carry out other activities essential for farming operations. Now, in my submission, Mr. Davis and the working group has approached the exercise back to front in a way that is not supported by the law. And I'll move on to explain that, in that first critical step, you work out what's significance, you assess it, why is it significant, you identify threatened and at-risk species, you map and plot them, is missing. The only information about significance before this panel that I can see in his evidence is paragraph 216, 2.16. And in that, he says, in summary, I can confirm that the areas mapped as A and C in Appendix 7 are consistent with at least some of the significance criteria. In my submission, that is wholly inadequate for this panel. And I'm just standing back. I say that because it is the ecological assessment that is being put forward as justifying the bespoke rules that don't apply to all the other farmers in Gore, just to these two stations. And if you're going to have bespoke rules and you're justifying it on the basis of ecological assessment, that ecological assessment needs to be robust. Once ecological assessment has identified significant Indigenous biodiversity, Section 6C of the RMA states that decision makers must recognise and provide for the protection of that significant Indigenous biodiversity. The district plan must give effect to the NPSIB, and the district plan must give effect to the Southland Regional Policy Statement. And I just want to point out that in the Southland Regional Policy Statement, the Council makes it extremely clear that there is a difference between significant Indigenous biodiversity and the need to protect that, and other Indigenous biodiversity that we must maintain. And that's Policy Bio 2 and Policy Bio 4 draws that distinction. And Policy Bio 2 states that significant Indigenous biodiversity will be protected to ensure no further loss. Now, just standing back, we actually missed this part of the discussion before you about Section 5, about sustainable management, about king salmon, and I can certainly address you on that if you would find that helpful, Commissioner Barnes.
That's how we started the day, so it would be a good thing to do. Thank you.
Okay, well, I can just sort of off the top of my head, if we look at Section 5, as one of my old lecturers used to say, is a bit like a collection of sugar and spice and all things nice. Okay, so the Act itself does not set out a direction for you. Section 5 is a collation of ideas. It does not prioritise any one of those concepts. The Act itself does not do that. The Supreme Court in the king salmon case said very clearly that communities can choose to prioritise one of the values in Section 5. And communities can choose to prioritise the absolute protection of significant Indigenous biodiversity in the context. So that's the law. Then we look at the planning framework. And the question is, has the planning framework decided to prioritise the protection of significant Indigenous biodiversity? And the answer is yes. Because the district plan, in accordance with the RMA, has to give effect to those higher order documents. NPSIB, the regional policy statement, it must give effect to. There's no getting around that. In relation to the Southland Water and Land Plan, the district plan cannot be inconsistent with that plan. So what we don't do at this stage is return to an overall broad judgment about what is appropriate in accordance with Section 5. This process has to give effect to those higher order planning documents. And that's why I'm emphasising their difference in how they treat significant Indigenous biodiversity, you protect it, versus maintaining Indigenous biodiversity at a district level.
And in that planning framework, because the MPS has come along after the RPS, would you like to comment on that?
Well, the NPSIB should take priority. Because the Southland Regional Policy Statement has to give effect to. They just haven't updated it as yet. But I want to move on, think about this concept of protection, because that seems to me to be the crux of this. What does protection mean? Protection is achieved usually through avoid provisions. You avoid clearance of significant Indigenous biodiversity, but it's important to understand the nuance. So avoid provisions can be unqualified, avoid full stop, you just don't do it, or they can be qualified, avoid unless. The following exceptions apply. So qualified provisions may provide limited justified exceptions to the avoid policies. You avoid clearance of significant Indigenous biodiversity, except for in very limited circumstances. And the MPSIB 311 allows very limited exceptions to the regulatory mandate to avoid clearance of significant Indigenous biodiversity. Gives us particular examples, and it's a very, very narrow exceptions pathway. But more importantly, what it also does is say, where we allow these limited exceptions to the clearance of significant Indigenous biodiversity, we're also going to apply the effects management hierarchy. So what that means is if you have, and it's been talked about, nibbles or death by 1,000 cuts, I think our experts will think, nibbling away at significant Indigenous biodiversity, that could fall within protection if the effects management hierarchy was then applied. I think I'm correct in saying this. Miss Williams also nodding. So you'd avoid, remedy, mitigate, offset and compensate. You don't just say we can nibble away at significant Indigenous biodiversity and that's fine because we've set a quantitative limit on it, that's protection. That is wrong in law. Simply wrong in law. And it's wrong in law because the activities and effects that would be allowed by ECOR2 are not included in the exceptions in the MPSIB. And furthermore, there's no attempt in those rules to employ the effects management hierarchy. So there's no specific need. If you're going to nibble away at them, you've got to remediate, you've got to offset, you've got to compensate. So just to summarise, in relation to the ECOR2 proposal, and I'm going to make 4 points, there is firstly, no clear significance assessment in relation to areas A, B, C or D. And there's no clear justification for treating A and B versus C and D differently. If we don't know why they've been assessed as significance, then we can't justify why they're being treated differently. The second point is, in my submission, and I stand to be corrected on this, there appears to be no clear understanding in the evidence from Stony Creek that the test, or Dr. Wells, that the test is to protect significant Indigenous biodiversity, as opposed to a general maintenance test for Indigenous biodiversity, or clear understanding that these concepts are different. The third point is there is no comprehensive evaluation of the law or the higher order planning documents as to how those higher order planning documents say protection can be achieved, along with what those planning documents say are permissible exceptions. And the fourth point is there is no justification for this exception evaluated against the higher level planning documents, or how any effects may be addressed through the effects management hierarchy, or consideration of the effects management hierarchy at all. So the result is that the proposed rules in ECOR2 allow for continuing clearance of significant Indigenous biodiversity. Now, as I've said, the proposed rules do attempt to minimise clearance by placing a quantitative limit on permitted clearance. But clearly there is actually clearance and loss of some significant Indigenous biodiversity, with no remediation, offsetting or compensation proposed. So moving on, I just want to make a couple of additional points. I'll talk about the agreement with DOC. I'll talk about Mr Wells's conception of a net gain, and I'll talk about the additional wording that Mr Heal has suggested be added to Eco R2. So first of all, I want to talk about the ecological suggestion by Mr Wells of a net gain. It's all right if you clear some significant Indigenous biodiversity over here, because, you know, over time, the Indigenous biodiversity not defined, over time, at unspecified time, will mature, will increase in some way. Now, what he means by that has not been entirely clear. We listened to his evidence this morning. That was helpful, thank you, but there's nothing in the papers that we've been able to get a hold of to understand this idea, and I think this is quite a crucial issue. We think he means that over an unspecified time, Indigenous biodiversity on the stations will mature, it may grow taller, the biomass may increase to account for the loss of significant Indigenous biodiversity. Now, my understanding is that this evaluation is ecologically contested, and the two ecologists we have from DOC will do their best to give you some response to that off the cuff. It may be something that if the panel is considering recommending Eco R2, when there's some dispute still about this, that it might be suitable for the ecologists to caucus on to better understand what's meant by that and what the problems might be, and whether there is any contestation about that. That could be an issue that is caucused on. But at the very least, the panel requires additional clarity on what is meant, and submitters should be allowed to file expert responses to that. It may be that I need to speak a little bit more about the difference between protection and maintenance. I put that in my initial submission, so if you need further discussion on that, I'm happy to address that issue. The second issue that I wanted to speak about was Mr Heal's suggestion that Eco R2 1 be amended to add wording to exclude some threatened and at-risk species from those permitted clearance rules. The wording was to effectively avoid clearance of woody threatened and at-risk species, and also stony areas to avoid the risk of fauna habitats being disrupted. However, my question is, why is the wording limited? You've got to avoid clearing threatened and at-risk species. Why is the wording limited? Shouldn't that wording be expanded to all threatened and at-risk species and significant habitats of threatened and at-risk fauna, in accordance with Section 6C of the RMA and the RPS? What is the justification for not including this wider wording? And Jusa Zammit-Ross can give some evidence in relation to that actually there are more than just woody, or potentially more than just woody at-risk species on that site, and actually lizards live in more than stony areas. The question then becomes, if Mr Heal's wording, or the wider wording I've just suggested, is included in Eco R2, the question then becomes, how does the landowner know what they're clearing? And Councillor Dixon has asked this question, and Councillor Bartlett, of the witnesses. How do you know what you're clearing in the absence of an on-ground ecological evaluation at the time? And how does the council monitor compliance with that standard? Now, there's been various suggestions given in the evidence as I've been listening this morning. You could train the staff, you could keep records, and so on and so forth. But the question remains, how do they know what they're clearing? How do you monitor it? Well, the best way to do that is to do it through a restricted discretionary activity and to have the proper assessment before the decision maker at the time. And that challenge is exactly why Liz Williams states the appropriate process is to make the clearance of significant Indigenous biodiversity a restricted discretionary activity with the accompanying assessment at the time. And finally, the last point I want to touch upon is the 2015 agreement with the Department of Conservation. DOC greatly appreciates the collaborative conservation efforts of Ian and Annette Tulloch in fencing off 127 hectares of significant Indigenous biodiversity. That does include threatened and at-risk vegetation. And that's on Stony Creek. It borders Croydon Bush, and that was a critical factor for DOC, that it was actually an extension of the reserve and the Indigenous vegetation on the reserve. DOC paid for the rabbit-proof fencing. It's rabbit-proof fencing in that area, and they provided DOC expertise, and the time and the gracious work that the Tullochs contributed was also remunerated. It's important to understand that some of that area was replanted. So there's a couple of factors there for you, and I'm making this point because in answer to Councillor Dixon's question about the historical evolution over time in the photographs and how we know that Indigenous biodiversity in the area can gain, there can be a net gain, Mr. Wells actually used this area, I think I stand to be corrected, as an example. It's really important to remember, since the early, I can't remember when this work was completed, it was earlier than the agreement, wasn't it, Jusa? 2013? I think so, 2013. Yeah. That from that time, that area has been subject rabbit-proof fence, replanting, and careful management and stock exclusion. So I'd just say this, be quite careful of using that to show that there can be a net gain of biodiversity on the station, because it's a very particular management of that area. But I do want to talk about the legal relevance of that agreement. It's really important to understand. I mean, that agreement was to provide some biodiversity funding to the farm to fence off a really critical area. That agreement is not registered on the title. It does not run with the land. It is an agreement that is not binding on any other person other than Ian and Annette Tulloch. It is not binding on any future owners. It has no impact on the district plan or the rules. Under proposed rules Eco R2, that area could be cleared. Now, that might be a breach of the agreement with DOC, and there are dispute resolution provisions to go to mediation and arbitration in that agreement, but it would not be against the proposed district plan rules that you are being asked to recommend. So DOC's submission and our evidence and my legal submissions are all towards the submission that Eco R2 be deleted in its entirety and the stations be managed in the same way that all the other farms are in Eco, with Eco R1 in Gore. If that submission is not accepted and the panel is minded to recommend that Eco R2 is included, we would suggest that the additional wording that Mr. Heal has included, has suggested be included to avoid threatened and at-risk species, not limited in any way, but threatened and at-risk species in the habitats of significant Indigenous fauna. But more than that, if Eco R2 is going to be included, then there needs to be some protection in the plan for that 127 hectares. There should be a map and bespoke rules to protect that area with unqualified avoid rules. And I've spoken to Miss Williams today, and she would, if that's the approach that the panel takes, despite our submissions, she'd be happy to help in drafting that. Now, those are all the points I was going to speak to, and unless there's anything that you'd like me to expand upon or I haven't made clear, that's really what we say about the Hokonui Hills Eco R2. What I haven't talked about, of course, are our two other submission points. Firstly, that we would recommend there be indicative mapping of the Mataura and its margins. The panel has docs evidence and submissions in relation to that. I'm not going to address you on that point. There was an invitation from Council to DOC to help with that, if that was the recommendation of the panel, and yes, of course we would be willing to help with that mapping. The second submission point, core submission point, was in relation to amending Eco R1, specifically Eco R1 Rule 1's Rule 1 L, M and N. We're pleased to see that the Section 42A report writer, supported by Dr. Wells, recommends the deletion of Eco R1 1N, which was about clearing 15 years, vegetation that was less than 15 years. And we're pleased to see that. And again, in relation to the other points, the panel has docs evidence and submissions in relation to the other points. I don't propose to specifically address you. So I'll leave it there. I'm conscious I've spoken for quite a long time and that there are other people waiting, but I'm very happy to answer any questions or points of clarification that you'd see.
I do have several questions, but questions to the other witnesses may actually take care of them with your input at that time. So just restricted to the legal submissions we've heard, are there any questions from the panel?
Yes, I'm grateful for that just thorough, careful step through. It's helpful to orient the rest of the day. So you've mentioned caucusing as a potential between the ecologists. Would you see value also in the planning side of things potentially? Because they sort of run as a natural consequence one to the other. So if there was to be, would you see it as logically having both ecological and planning?
We're absolutely in your hands. If that would assist the panel, of course, DOC's willing to dedicate those resources to assisting. Yes.
And so also acknowledging, your initial, what you've laid out in terms of accessibility to the information ahead of the hearing. So that goes along with the same thought pattern.
Yes.
That you've suggested potential caucusing, yep, and so it could have the two elements potentially, up to us, but you're willing to. What I really wanted to talk about was the protect and maintain, and because of that acknowledgement that really we move from Section 5 and Section 6 into the MPS, and that's our most recent direction, and it's got some commonality in terms of the significance criteria with the RPS, and so there's nothing thrown up that's tussling between the two in terms of, but it was when you were talking about the sort of protect and avoid and maintain, I really want you to help me with this, because when I look at the National Policy Statement and its objective 2.1, so right at the start of the day we were talking about the protect directive in Section 6, and then Section 31 using the maintain language, and then when we get in to the MPS, it's saying we want to maintain so that there's at least no overall loss. And we're achieving this in a number of ways, and one of those ways is by protecting and restoring Indigenous biodiversity. And so even when I'm reading this objective, the significance test isn't sitting in the objective. So the significance test still comes through to us from, like it hasn't disappeared. It's there in the criteria. But I just wondered if it's not quite so simple as you'd outlined. I can understand why you outlined it the way you did, but I don't know if it's as simple as that in terms of protect, significant, avoid, that line, and maintain other things. I'm not sure that that's what this objective is saying. So I'm thinking about, when you were saying that, it made me think of the NZCPS and some frameworks that we're familiar with from the NZCPS. But when you look at this MPS, that objective, it's looking and sounding quite different, and this is probably a planning thing, but I just wanted to just test that a little bit with you, that idea of what protect means and what maintain means, and with this new instrument, because the new instrument is looking and sounding a little bit different.
So, of course, Section 30, Section 31 for you has the imperative of maintaining Indigenous biodiversity across the district. The way I visualise it is that protection is a subset of that, right? This discussion, and I put this in my original legal submissions, this discussion took up an awful lot of time before the proposed Otago Regional Policy Statement. And there is a lovely discussion of that in the panel's recommendation. And what they said, and I like it because they agreed with me, is they said that protection is a different standard to maintaining. As part of the overall calculation, yes, you're going to be doing different things depending on how you've categorised that Indigenous biodiversity. With significant Indigenous biodiversity, you're protecting it. And that's part of the overall calculation. Protection, they found, is an ex ante, a sort of preventative measure. Whereas maintenance is a lot wider, a lot more flexible. So if you've got something really significant, if you've got a grove of Alaria hectori, protection is to prevent them from being cut down. Right. However, with other Indigenous biodiversity, you can be more flexible. You might allow this area to be removed, so long as you know there's going to be some remediation elsewhere, or somewhere else is going to develop in terms of the extent or the maturity of Indigenous biodiversity. That sort of balancing act can take place on a maintenance scale, but within that Venn diagram, if we look at it that way, there's this area that is protected because it is significant. And that's why I started my submissions with, you can't even work out what the correct management is until you have done that ecological significance assessment and we are clear why that area is significant. Perhaps I should, perhaps I can actually give you the part of the PORPs that discusses this, because it was done very nicely. Yeah. With similar pressures to Gore, incredible amount of rural land and farming interest to which this seemingly dry legal question, what does protection and maintenance mean, was critical.
Just wanted a little clarification. Clearly DOC has identified that 127 hectares as significant, to use your phraseology, and that's where most of the rarest species reside. So in that respect, that certainly would be, at the moment, more than maintaining. It would be protecting, wouldn't it, to use your words?
No, there's no protection in the district plan for that.
No, I'm not talking about the district plan. I'm talking about your agreement with DOC, your agreement with the Taluk. And what you've now invited the panel to do, although you have an agreement with Mr Tulloch, is to encourage or invite the panel to impose some enduring control over that 127 hectares. When you already have an agreement, working agreement with Mr Tulloch, surely it is your position to enhance that and further it and then deliver that to the panel so we can incorporate it in the plan. It just does not seem a very attractive option to require or suggest that the panel, in effect, seizes control over that piece of ground.
Well, with respect, Commissioner Bolger, we disagree with Eco R2. So our submission...
You're more than likely, yes, but that's not what I'm talking about.
Do you want me to answer?
I'm talking about your agreement with Mr Tulloch, and you are now inviting or inferring that the panel should take over your role and seize control over that land. I would suggest that, you know, we would certainly be able to incorporate an enduring agreement if you can secure it with Mr Tulloch, who is the landowner, for an enduring agreement in perpetuity.
The first response is, in response to your suggestion that we're seizing land, the Resource Management Act has no connotations of property ownership. The Resource Management Act sets out a clear regime in my submission, including through the higher order policy documents set down by central government and the regional council as to how we are going to manage significant Indigenous biodiversity for the benefit of everybody. If Eco R2 is the recommendation of this panel, which DOC does not agree with and has filed submissions opposing, then there has to be some protection in the district plan for that area.
Okay, and what I want to come back to in questions is for you, for the DOC team to take us through why there is no protection, and that's a separate issue. What I propose to do now is just adjourn DOC, and let's hear from Coral at the back there, and you can stay where you are. So, Coral, do you want to come forward to the spare seat that we've got up here for your presentation? We heard from Brett Heisted and his team just earlier this afternoon. So once again, welcome, and in your hands, and you may want a glass of water or whatever there, but please proceed.
Okay, so once again, thank you for the opportunity to talk today. As you know, I'm not an expert, just someone connected to the land. I've probably a few more questions today than last time, so do you want to answer those at the end, or do you just stop me as we go through? Any preference?
Let's hear.
We'll see what it is.
Yeah.
Go from there. Okay, so right, there isn't like a huge amount of native biodiversity on our farm in relation to its size, but what is there, I'm keen to retain and increase where appropriate. Thank you to the council for leading the working group and getting people around the table and having conversations. It has been an invaluable process having the working group nut out a more manageable and logical process for all involved. The consensus reached on the rule section in the creation of Eco Rule 2 for the Hokonui Hills area is a step in the right direction, and I am pleased to see the 42A report reflects changes because of these discussions held and acknowledge our existing use rights. I see there are some further changes proposed due to the supplementary evidence, and as a result, I'm pleased the ecologist planners have explained the reasoning for the creation of Eco R2 to some submitters. Hopefully that explanation reassures them. The additional change Matt Hill has put forward following the supplementary evidence on the ecosystems and Indigenous biodiversity chapter, i.e. Eco Rule 2 permitted activity 1, where it avoids the loss of threatened or at-risk woody plant species in Hokonui Hills rocky habitat, refer Appendix XX, is necessary for the following purposes. Makes sense. Just to clarify, is that for the areas of J&K or maintenance or both? Wasn't sure on that front.
Yeah, you're correct. We established this morning it's for J&K.
Okay, cool. Yeah, just on a side note and just listening to a wee bit of what you guys were talking about, a lot of those areas, if not all, I mean, from my point of view, they're areas that you would avoid anyway. They're like matter of course, they're not areas where you could easily run through a fence or a track or whatever. Like, you know, it's, I guess there's a common sense approach, I guess, comes into it from a farming perspective, I guess, is what I'm saying. So, yeah, I just made that assumption. The reference to XX was probably referring to Appendix 7 that we're now looking at. Yeah. So basically those areas are now identified as SEVAs and EVAs, or however you shorten that to. So can I also seek clarification on Eco Rule 2.1I, which refers to the maintenance of existing fences and tracks? So are replacement fences considered under maintenance?
Again, we had a conversation this morning and alternative wording was being suggested so that it reads the maintenance, repair, replacement and upgrade of existing lawfully established fences and tracks.
Okay, cool. So you've covered that off. Thank you.
Eco speak of the ecologist when transferred into planning speak made some assumptions that by making that addition is a lot clearer.
Yeah, no, that's cool. That's kind of where I was coming from as well. Thank you. So I just think it's important to note that in a farming environment we need to be able to maintain, replace and establish new fences, maintain air tracks, just normal farming stuff, and it's, you know, both health and safety issues on farm for staff and off farm if it can't be done, because inadequate fencing could allow stock into areas that they shouldn't be, or we may see inadequate control of some pest plants. Thank you for changing that the whole waterfall range isn't an SNA, only the Dollamore Park and Croydon Bush Reserve are SNA 1 noted in the plan. So if I'm reading everything correctly in the eco chapter and related evidence, the SEVAs are now basically an SNA. Is that a fair assumption?
Say that again.
So a SEVA is basically an SNA, is that correct?
I think the answer we had was you can't assume that it is, but the values are probably close to it.
Close to it, okay. So just wanted to make a bit of a comment
and that evidence is contested by DOC as well, so we've got to work that stuff out.
Okay,
Yeah.
Work in progress.
Thanks.
So just a comment on the economic report side of the ecological chapter. I feel that the assessment of the economic costs is possibly on the light side, due to, from what I've read, there may have not been an allowance made for landowners' time, wages, etc., along with the fact that we may have to employ a consultant at a considerable cost to complete a consent application for a restricted activity scenario. The report did say that there may be an additional cost if planners were required though, so I guess it kind of covers it a wee bit. It had been stated by the planners at one of the previous hearings that it did not need to be a standalone document for sections relating to the Hokonui Hills area NFL, as a specialist consultant would be completing the application in that instance, and they would know where to look for everything basically. So yeah, that's a fair comment, but I'd also ask that it be straightforward enough or close enough or clear enough as to which overlays apply, that those landowners who wish to complete the applications themselves could do so. It would certainly be my preference to complete this myself in that situation, instead of having to pay someone to do it. I guess we'd be able to talk to the Gore District Council planners at the time for guidance in some respect on that. Yeah, so just saying, I guess overall, whatever the plan ends up with, it's just be good to have clear directions and easy to understand how we implement it on a day-to-day basis as well.
Thank you for that
That's
feedback.
pretty much me.
That's appreciated. So any questions from the panel?
before questions, I just wanted to tell you that there's a section of the National Policy Statement that deals with established activities. So you were asking that question as you went through. And so it says that continue where the effects of the activity on an SNA or a significant natural area, so whatever is determined to be a significant natural area in the Gore district, that the activities are no greater in intensity, scale or character over time than at the commencement date. So that's like if you're doing a replacement and it's the same intensity, scale and character, then it doesn't fall foul of the national direction. And it also says does not result in the loss of extent or degradation of ecological integrity of the area. So those are the basic tests for if an existing activity can rely on the exemption.
And I'm mindful of what you told us at the previous hearing, where really development on the property has reached its advanced point and there's really very little more that can be done. So in terms of what's there existing and the way that it interacts with that, it might give you some confidence.
Yeah, it does to a degree. We'd still probably have a bit of fencing and stuff to do, but most of it's complete.
Okay, any other questions, Cliff?
No.
Okay, there's no further questions, and I think it's a brief input today, but it's really the culmination of a lot of work that you've been involved with in the last 6 months or more, and that's appreciated. Thank you. And thank you for coming today.
You're welcome to stay and listen, of course.
Yeah, so returning to DOC, and I just want to pick up on something that was said a few minutes ago in terms of DOC having opposed Rule 2, which of course Rule 2 wasn't there previously. What you opposed was the concept of having a bespoke provision, and really what's come out in the reports for you, I guess, is the first time that you've actually seen a set of rules. So I was just really wanting to get that in the record, that in terms of the findings.
And can I also just clarify that we're not expecting anything more in relation to that 127 hectares than the agreement provides for. We're not expecting an extension of that. We're expecting, what I'm saying is that if Eco R2 is included, it does allow for continuing clearance in that area.
Yeah, so
okay, and what I'm saying is that you really need to, if Eco R2 is going to stand, then you really need to be in the district plan, be having some reference to that protected area.
So
and we're very happy to help draft that. We're not suggesting that anybody else do the work or anything like that.
So why doesn't Rule 2 protect that area?
Because it's if it is mapped as a SEVA, if it's mapped as an IVA, which hopefully it isn't, then you've got
and that's my question.
Well, that's the question. We're not quite sure at the moment, but
we've been told it's a SEVA.
It's a SEVA, right? So then you've got Eco R21K. It's located in area C or D. You could have new fences covering an area of the quantitative limit. So that has not been excluded from J or K. That's my point.
Covering an area of less than 1250 square metres in K per 5 years in C, or 50 square metres in D. So which area are we talking about?
I think it's C.
Sorry?
C.
C. So it's 250 square metres a year. But I guess you don't want fences through that area at all. Is that what you're saying?
No.
Right. Okay.
the basic point that you were making right at the start, that unless it's specified infrastructure in the MPS, it can't rely on the exemptions for being in a significant natural area. So, if, and it's a big if at this point, an SIVA is an SNA according to the MPS, then only new activities that are specified infrastructure could rely on the exemptions in the MPS. That's the upshot, yes?
Yes, and that's not how the rules are written at the moment, of course. Yeah. So it's just 311, MPSIB 311.
I was also wondering, in that area, you said some of it has been planted.
Yes.
So, in K of Echo R2, the works it's permitted for clearance. The works relate to indigenous vegetation that was deliberately planted.
It's indigenous. It's, as I understand it, there was planting. Jusa, do you want to answer that? You might be better to answer that.
Hello. So yeah, there's been some planting of Alleria hectori. So that species is threatened, nationally endangered. And part of the reason it's endangered is it has a recruitment issue. So it needs disturbance and fresh soil for seeds to be able to germinate, and that doesn't happen often anymore in a farming environment. It's usually covered in swaths of grass. So we have gone in and planted additional Alleria hectori, and that's to create kind of a multi-aged population to sustain that older population and add new genetics into that population as well. Otherwise, you're just going to have a population of very old trees that can't actually reproduce into the long grass, and they'll eventually just die off. So that's part of the planting, was to support that ecosystem.
I was sort of thinking that if this MOU changed hands and it was no longer there, and this rule was in here that you can clear indigenous vegetation, that could be a threat.
Yes. Yeah. That's right.
Okay, shall we move on then?
Well, that's my legal submissions over with. I'd like to call Bruce McKinley next, if that's possible.
In your hands.
Now, Mr. McKinley's evidence was in relation to mapping the Mataura, and he has a very brief executive summary in relation to that, which is his explanation as to why he thinks the Mataura should be mapped. It's just to indicate the significance of that area and to help plan users understand the plan and the rules. But actually, as I indicated at the outset, it's Mr. McKinley who's had the capacity to consider the additional ecological evidence over the weekend, and he can perhaps answer any questions that you might have about the methodology that's being used in relation to assessing the Hokonui Hills, why we have significance assessments and what they usually look like, and also this idea of if we cut down significant indigenous biodiversity, even if it's a small amount, it's okay because you'll have a net gain with the growth of additional biodiversity. So,
Can I just ask you too, just on top of that, so the RMA takes into account social and economic values as well. So how would you approach that in this situation?
yeah, so that's where I sort of talk briefly about the Supreme Court decision in King Salmon. You're right, Section 5 is this collation of issues, including, of course, economic well-being and socio-cultural and health and safety and so on and so forth. And what the Supreme Court said is that that's the law, and then how we apply that in a particular context comes out in the planning hierarchy, starting with national policy statements at the top, and then going down to the regional policy statement, the regional plans, and then the district plans, fortunately at the bottom of the hierarchy. So the national, central government can choose in a national policy statement to prioritise one of that collection of values, right? And that's where we see the NPSIB doing that. Okay, so in relation to, we would say, in relation to significant Indigenous biodiversity, they say, the NPSIB says you've got to protect that. There's very limited exceptions to protecting that. And if you do allow those exceptions, then you also apply the effects management hierarchy. And then that sets the national direction. So it's a manifestation of what Section 5, how Section 5 should be applied in relation to significant Indigenous biodiversity. Regional councils have to give effect to that. District plans have to give effect to the hierarchy. Does that? Yeah. And the important thing about that is that in 3 decisions, 3 Supreme Court decisions, King Salmon, Port Otago and East West Link, the Supreme Court has said that's the guide, that's the framework. What the panel doesn't do is look at all that and go, yeah, well, that's great, but we're going to go back and look at Section 5 now and balance everything up and think how we're going to provide for economic wellbeing. You have to give effect to that. So the planning hierarchy, how Section 5 has manifested in that planning hierarchy. Yeah, no, that's okay. Bruce?
Thank you very much. Good afternoon, Commissioners. So just to start with my core evidence, which was focused on the Mataura River. So the executive summary points out that the Gore District does not have a wide variety of ecosystems or an expansive rare, threatened or at-risk ecosystems. It does, however, contain a significant amount of the middle reaches of the Mataura River, and I described that in detail in my evidence. So the Mataura River and its margins provide significant habitat for black-billed gulls, which in the New Zealand threat classification system are classified to be at-risk declining, and I present some evidence to be able to support the opinion that this habitat should be met to ensure that the objectives and policies of the district plan can be implemented efficiently. And that's sort of the core of the evidence, and start there and be happy to answer questions on it.
I understand that black-billed gulls actually change their nesting quite regularly, so it would be very hard to specify an area, wouldn't it? You would need to have an overlay, perhaps.
Well, that's right, and that's the point of the evidence, is to sort of explain that they are colonial nesting on the beaches of Mataura, that those beaches are ephemeral in as much as they move according to floods or other effects, and that the gulls respond. We also know that as a result of disturbance events, that they will move. So, in some respects, the point of saying this is not about the breeding colony area, it's about the fact that gulls exploit all of the river, and that they'll move from a colony at point A, and they'll forage up and down the main stem and bring food back to small chicks and to sustain themselves. And it gets worse than that, because they will also follow the plough. So they'll move out of the river into active farming and priority farming areas and forage for invertebrates there. So the point of the evidence is to try and move beyond X marks the spot, which is subject to change, and talk about the river as a whole ecosystem within Gore.
Is that part of the natural character of the river?
Which bit?
Well, the concept that you've just described, is that part of the natural character of the river?
Yes. I mean, I think that in terms of black-billed gull foraging in the river, that is an essential part of the character of the river.
Are you aware that the panel has put out a minute seeking feedback on having a standalone chapter that's dealing with natural character? And if so, is this the appropriate place where it should be, rather than in a chapter that deals predominantly with vegetation?
No, I wasn't aware that had happened, but if it fits more logically in the planning framework that the panel's creating for the district, then happy to work on that. The evidence won't change. Where it sits in your package is up to you.
Okay, so we recognise it in the plan. If we go down that way, then what? Because we don't receive resource consents for people to do things in the river. That's a regional council function.
But you do create control of land use along the river and in the riparian margins. So there is this really fuzzy thing about your bit and their bit, but there is a cross-boundary issue, or there is a legitimate interest of the district council in the management, or no, describing the riparian areas and the values that are present, so that when resource consent comes in those areas, in the plan you're informed as to what the values are.
Okay, and I think you just preempted my next question in terms of, you said when resource consents come, because we don't get resource consents for the things that you described that attract the birds. The type of resource consents we would get in the adjoining areas would likely be subdivision, and much of the floodplain adjoins the river, so there's not a lot of other development that takes place. So I'm thinking through to the next step. What actually is the risk? What are the things that are at risk for the birds that you would want us to take into account as part of the resource consent process?
I guess I think I'm approaching it from a slightly different perspective, which is that the values that are present on the river indicate that the river is a significant natural area, and I think other evidence supports that. What I'm suggesting, or what I'm requesting in my evidence, or the conclusion I'm drawing from that, is it should be treated equally as other significant natural areas which are mapped in the district plan. And so I'm suggesting...
Yeah, I know where you're going. Yeah.
So what my conclusion says is that this SNA should be treated equally with other SNAs in the district. Now, what you highlighted for me just now with your questioning is a slightly different regulatory framework, because it's not the same as other parts of the district. So the challenge is to recognise it, but also respect what is deliverable here and what is deliverable through the regional plan.
And given that your masters, being the government, have told us not to do any mapping of SNAs for the next 3 years.
Well, it's for you to choose, but maybe it's a planning matter. Rather than, that's not an ecological question.
Right. Well, we were suggesting it was indicatively mapped, like the other SEVAs.
Yeah, well, I want to come back to that when we talk to you in terms of what indicative mapping means, particularly where you want to assign rules to it. So you've got some more. Maria?
So we do have an overlap with the activities on the surface of water. And so we've actually been looking forward to Doc coming into this process, because we didn't get a chance to see you during that hearing, and so this is our chance to actually spend some time with you and the evidence that you've brought forward, because when we were in that hearing we didn't have the benefit of your evidence to support the concerns being raised around use of the river main stem for jet boating at different times of year, that kind of thing. So in terms of the black-billed gulls, the main things that we do have responsibilities for are the margins and those activities on the surface of the water, and we know we've got that ASW chapter, we've got a draft natural character chapter that's come into the mix that wasn't there at the time of notification. That's something we have to make a decision on. That's specifically brought in to deal with section 6A rather than what we're specifically dealing with here. So there are slightly different tests or slightly different analyses that go on when you're looking at that part of the Act, and natural character versus a pure ecological assessment. So I guess that's my way of saying that when you're bringing us the black-billed gulls, those are probably the three parts of the plan that could have something to say. The difficulty for us is to work out which of those is best suited, and I think there is a primary intersect with the activities of surface of water, which corresponds with the DOC submission point on that chapter. And so there would be a relationship, I guess, with infrastructure that came into the margins and sought to cross the river, for example.
Yep.
And so what you're saying is, if we're going to treat the Mataura River in the same way that we would treat some other area of significance, like a habitat of significance, so instead of calling it an SNA, we could acknowledge that it's a significant habitat under Section 6C, and that there are significant Indigenous species that live there. And so you would want the eco chapter to have something to say around infrastructure coming into the margin and crossing the river. And that's a key thing that this chapter might do. And maybe the natural character chapter at the moment is objectives and policies that can inform a consent, because that was the gap that was identified. So there's no other rules sitting in there. So the rule framework would therefore then be in ASW and ECO to manage what's happening for the black-billed gulls.
That's right. So yes, that's all legitimate. I'd like to give you a long answer about the question of activities on waters. So some years ago, I did an exercise on the Dart River investigating the impact of jet boats on nesting birds. In that particular time, it wasn't black-billed gull, or no, at that particular site it wasn't black-billed gulls, but it was the threatened ryebill and oystercatcher and banded dotterel. And we set out to investigate what happens when a jet boat goes by a nesting or a foraging bird. And I was able to show that the wake of a jet boat going by moves significant distance up the beach into the foraging areas of these birds in the nesting time. And I published it as a scientific paper, which we can give you copies of. But there's the use by a river of a jet boat during breeding time will displace foraging river bird specialists from breeding. And if it's the wrong configuration, it can also affect nests by flooding them. So that investigation, which led to that scientific report, still underpins the advice that DOC gives to people who want to hold events on rivers about when you should hold it, which is between February and September. And that was actually that also fed into a resource consent hearing about commercial boating on the Dart. Yeah, right. I'll find that for you.
I think that would be helpful.
And
sorry, you said February to September
is when the birds are away.
Is when the birds are away and they come back to nest September to Feb.
Yep.
So if you're going to be whizzing around on the river, do it between February and September.
Correct.
I think I was the reporting planner in Queenstown at the time when that was being considered through the district plan review. But we won't tell them what year it was. Okay. And so I guess it kind of leads on to DOC had a submission into the Natural Features and Landscape chapter, and they wanted matters of discretion added to all the rules in that chapter that required assessment of the Indigenous biodiversity values. And it may well be a planning issue in terms of how do we provide a link that's effective and efficient between these different chapters, and in fact should there be a priority on these Section 6 matters. And I guess from an ecological point of view, the value of what you've presented is there is a value here that needs to be recognised. It's over to you, the planners, as to how that should be done. Is that a fair comment?
Yes, I feel so. I mean, the expertise I bring is to describe values and where they are in space and time. It is, well, I think it's it's a planning function to actually describe the policies and rules to deliver that.
Thank you. So you've created the framework for moving forward. Any other questions from the panel? Maria?
I'm actually more interested in you, if there's anything else you want to bring to our attention. So what's sitting squarely in here is the Matilda River as a habitat and the species that live there. You've also provided some of the planning lead-in and the definitions and things like that we've already canvassed. So really, is there anything else in your evidence that you want to highlight to us?
Excuse me. On pages, in paragraphs 29 to 32, I talk about the threat classification system. So that applies equally to the values that Judith Zammit-Ross and other people are talking about. So that's the framework for all New Zealand biodiversity. So that's just one point. And I would highlight that the black-billed gulls are endemic to New Zealand, and that Southland provides a significant amount of the habitat, and within that, the Mataura is a very important habitat. So it is important to recognise that and to go the extra mile to actually create a framework to look after them as far as you can.
Are there any other birds that you feel that we should be including in that, or just the black-billed gull because it's endemic to Southland?
It's endemic to to New Zealand, not quite Southland. So I've listed at paragraph 33 the other riverbed birds that are present in Southland. So there's that community. When we looked through the Section 32 reports and the other documentary work that Wildlands did, no other species jumped out at me as priorities for the district.
And so there's a degree of confidence in that Wildlands assessment that fed into the Section 32?
Yes.
I think this is a planning question, the one I've got in my mind, so I'll let that go.
All right.
Thank you.
Item next.
Judith Zammit-Ross is going to give a brief overview of her evidence. I'd asked her
Mike. Thank you.
say a lot again. Sorry, thank you. Judith Zammit-Ross is going to give a brief overview of her written evidence, her summary. I've also asked her to address some specific questions in relation to the additional evidence, but with the panel's leave, perhaps Bruce McKinley can also answer if you have any questions about the additional evidence in relation to the Hokonui Hills, because as I said at the outset, he's the ecologist that's had the capacity to carefully consider that evidence over the last day or so.
Thank you. So basically, my executive summary from my evidence that was submitted on the 7th of February, and some of the questions have been answered after that, but it was based on the vegetation mapping exercise and the identification of CVAs, SIVAs, and IVAs, the known botanical values on Stony Creek Station and the past lizard records for Hokonui Hills precinct area. I recommend that I recommended that a botanical and lizard survey is undertaken of the Hokonui Hills precinct in order to understand the biodiversity values present. And these surveys should be undertaken before any land disturbance or indigenous vegetation clearance occurs on the property, to assess the ecological effects. I've also had a chance to look at the supplementary evidence briefly that was given to us on Thursday. And so there's a couple of points that I just want to make regarding the lizard survey. So Kerry Knox undertook a one-day lizard survey of one location on Stony Creek Station. And I don't believe that that's sufficient to give enough information on the lizard diversity of the Hokonui Hills precinct. The methods he used were a walk-through assessment, lifting up rocks. He saw one lizard, and that's it, outside of the search area. So in 2021, Kerry Knox recommended to the department that Stony Creek Station was one of the high priority sites for Southland green skink survey. Now, Southland green skink are nationally critical. That's the highest threat classification in New Zealand. Once again, he's only looked at one location and one day, and a very simple method that he's used to have a full understanding of the lizards that are present on site. A comprehensive survey would involve, for example, the setup of artificial cover objects or pitfall traps over multiple habitats throughout the property. And if we're looking at Hokonui Hills precinct, then that would include Wantwood Station as well. And then if they were using artificial cover objects, they need to settle into the environment for up to 6 weeks before they can be monitored. So even then, Southland green skink are very secretive, and they don't always use the those devices to hide under. So, you know, you might want to use a multiple range of devices to actually see what's there. We know that in 2001 there were a diversity of lizard species there on Stony Creek Station and on Wantwood Station. That included Korero gecko, cryptic skink, and Southland green skink. So I realise that's a long time ago, and they may have disappeared without any predator control and with habitat degradation, but I just want to emphasise that a one-off survey of one location is not sufficient to say that they're definitely not there. What else would I like to say? In regards to the supplementary information that we got on Thursday, Mr. Wells in point 38 suggested that a list of woody plant species, indigenous plant species, could be listed and they would be avoided. I agree that that is a potential option. I don't agree that an everyday farmer or a non-botanist would know how to identify the Olearia species, for example. Olearia hectori is deciduous, and it can be easily confused with other Olearia species, for example. There are some non-woody at-risk and threatened species on the property. Carex strictissima is threatened, nationally endangered. It's a wetland species, but it can also grow in non-wetland environments. So that's just an example. Both Mr. Glenn Davis and Mr. Andrew Wells mentioned 2 species of native broom that aren't on that list of woody species. They both have an at-risk declining threat status. And Korwhai, which is locally rare, if there was going to be a list, that should be added as well. So that's just that point. To do with point 2.20 of the supplementary evidence from Mr. Glenn Davis. In regards to the photos and looking at the change in vegetation from 1940 to 2024, we've now found out that stock are present throughout that property, and so that's not those images. They suggest an increase in cover, which is great. We don't know if it's an increase in Indigenous cover or an increase in Indigenous and gorse. That's not that clear from the images. I do think that stock, depending on if the sheep or cattle, will be suppressing the successional processes. So I disagree with what Glenn Davis said earlier on around that. And also, they will be browsing, they will be, trampling and wrecking Indigenous vegetation in those communities. They will be eating and changing the composition, so there may be less palatable species there now, and that may change the community composition. So those sort of things haven't been talked about. And also, it's just a visual representation, that the mapping or those aerial images, there's no actual monitoring showing change over time. So we can't be clear that diversity has actually increased. Cover has increased, but we don't know if diversity has increased. So I just wanted to put those points forward. Thank you.
When Doc planted out the Olearia hectori, where did it source the plants from?
I'm not sure about that. I'd have to come back to you on that one.
And even with the Ko-Fi, are they from the same ecological district? And if they're not, do they deserve the same degree of protection?
So from my understanding, the Ko-Fi is naturally growing on both Wantwood and Stony Creek Station, from what I've read. I imagine that the Olearia hectori were grown from locally sourced seed, collected from the older trees, grown at a nursery and then taken back to be planted there. But I don't have any written evidence. I'd have to try and find that for you.
Because some of my Olearia are sourced from a local nursery, but they're not from the same ecological district.
Yeah.
And so when you talk about the integrity of plants in an area, to what degree is locally sourced an important component of that?
Yeah, good question. Is that a question for me? Or?
Yes.
Okay. Yeah, so it's important in this case, maybe not for non-threatened species so much, but for threatened species, having eco-sourced genetics is important because they are locally adapted to this environment. They're unique to this environment. You may want to mix them around a little bit. So I know there's another population up in the Waikaia Valley of Olearia hectori. So maybe to add genetics, you may mix, but I don't know. There'd have to be some thought put into that. It's a large population of 130 trees, so there's probably a fair genetic variability within that population itself.
When does a group become significant? 6 trees, 20, 100?
Well, I can't answer that one.
I've got 6 growing together. Is that significant?
Significance to me in that sense would be when it's self-sustaining and it's got a viable population and it can look after itself.
Right.
Yeah.
I can actually confirm that the Olearia hectori was taken from seeds here, because
Great.
I know the person who grew some of them.
Oh, good one. Thank you.
Any other questions?
Any further questions?
Have you had a chance to consider the methodology at all of Mr. Wells? Because I know that what's been put in front of us is the significance criteria assessment is missing, like the significance test. So what we've got is Mr. Wells saying, we've looked for likely significant Indigenous vegetation and likely non-significant. So it started to approach the assessment of significance. So what specifically would you be looking for to add to the methodology that's been used by Mr. Wells and Mr. Davis in this case?
Well, I'm not unsure what the methods were for the botanical surveys, to be honest. So we know that Mr. Davis's team visited 24 sites. I don't know what their methods were for survey. My method would be to firstly go to known locations or at-risk and threatened plants, if you can. Obviously GPS and plot or map those plants. Then search those communities for those similar communities for additional plants. And I mean, it depends on the level of survey that you want to do. I mean, it sounds like for this case, it would be a recce, so, you know, walking through each community, noting down the species that you find. And I would definitely map and mark the important species and ecosystems that you're finding, so that that can be provided to everyone for this process. Bruce, do you want to add any more to that?
So I think, yes I will, thank you. I'd just like to add that as well as the methods which my colleague has just described, which reflect what's in Appendix 1 of the NPSIB and as a version in the Southern Regional Plan, there's the context and the purpose for which the assessment has been set out to be done. And I think in this case, the supplementary evidence of Glenn Davis is quite important, because in paragraph 2.16, he says that the purpose of the working group which drove this process was not to consider ecological significance. Rather, it was to use ecological information to develop a suite of rules that would be cognisant of the biodiversity of Stony Creek, while providing scope to allow installation of fences and tracks and carry on other activities. So the starting point for the work that led to the methodology was not about ecological significance. It was about working within the idea of developing rules. So the point I'm trying to make here is that if you don't send a bunch of ecologists out to with a clear brief to undertake an ecological assessment, then you can't really then turn the results of their work into an ecological assessment of significance. So I'm not blaming the ecologists, they did what they were asked to do, and it's laid out in Mr. Davis's evidence, but it's quite different from then saying, we did some work which enables us to draw with confidence an assessment across this part of Gore District of the ecological significance of the values that are present. So I think the starting point is part of the problem that we've got in this discussion.
It's possible that there might be a difference between the evidence of Mr. Wells and Mr. Davis here. But I take the point. The primary point that's been made to us is, you know, the short time to sort of get to grips with this, that am I right in thinking that you're still feeling like there's information missing that you're looking for, that might be sitting in behind that you can't see? Is that still an issue for you, or?
Yeah, I personally feel that, as Jesus Emmett Ross has described, it's clear that the ecologists went to a certain number of sites over an area of the stations. They created lists of the plants that they saw there, and used that to sort of draw conclusions. And so what's not been reported in the evidence I've seen recently is the ecological context and how that might be representative of that part of the Gore District or the wider Gore District or the Hokonui Ecological District, which are all reasonable measures of the context within which that work took place.
So in order to inform this process and our decision in a way that is closer to the MPS Appendix 1 and the RPS direction, is we need the methodology laid out, the data that comes with it, and then the significance criteria assessment
And the conclusions that you
and the
draw.
conclusion. So those steps, we've got some bits, but
Yep.
we don't have all the bits.
Yep.
I'm just wondering who would do that critical assessment of Stony Creek, because there will be a cost in that, and there's already been a lot of costs.
The information could have actually been collated, but it hasn't been presented. So you're right, there's going to be effort, but whether it's field effort or review, I don't know. I can't describe.
And I'm looking across at the team who are present. It might be something that we need to come back on, have a wee confer potentially, because the logical thing to do at this point is we're hearing obviously a very clear position from DOC that's looking for something more from the evidence of Mr. Wells and Mr. Davis than is currently visible, and is that something that can be provided is probably the question. That's the basic question, by either Mr. Wells or Mr. Davis, or the combination of the two. It's a hanging question at this point. Essentially, those 4 steps, so what DOC is saying is to show that we have met and given effect to the MPS and the RPS. As a panel, we would need the combination of the method, the data, the filter of the significance criteria, and the outcomes from that significance assessment. And that might look like what we've got in terms of mapped areas, potentially, but without that full visibility, we can't then do the next steps required of us, is the position coming from, and I'm getting lots of nods. Yeah.
Yeah, I'm sorry, just to interrupt, I need a 3-minute break. I'll return shortly.